The federal government's plan to legalize marijuana starts by decriminalizing it. But even as that legislative effort goes ahead, there are many people currently incarcerated for activities that will soon be legal. Those facts raise some tough questions about fairness and may also give some ground for legal action. Annamaria Enenajor practices criminal and constitutional law at Ruby, Schiller, and Enenajor, and she joins us now for more. Good to see you. Thanks for coming in.
Thanks for having me.
Well, this is a situation. Once C-45 becomes law, there's still going to be people in jail for pot possession. What should we do about that?
Well, it's not just the people that are going to be in jail for pot possession. It's also the people who are going to have criminal records for the rest of their lives for pot possessions. And the reality is that these criminal records have a devastating impact on their ability to get jobs, participate fruitfully in their communities by volunteering with children, and crossing the border as well. So really, it's beyond just the deprivation of liberty. It's about a quality of life that more people than are just incarcerated have to deal with as a result of this legacy.
So let's pick those two things apart. For those who will still be in jail after marijuana is legalized, what should we do about them?
Well, I think that the way that the law is structured and the way that we constitutionally look at laws is that they have to serve out their sentence, because what they did at the time of the offense was illegal at the time.
But it isn't anymore.
But it isn't anymore. And so that raises the question of fairness, what we can retroactively do to assist these people, because we have come to the realization that marijuana and cannabis in general is a substance that should be dealt with more like alcohol, in that it should be regulated and it shouldn't be criminalized, because there is no benefit to doing that for society.
So do we say the day after this is legalized, all you people who are in jail for pot possession in the past, let's open the doors, you come out, you're free?
It's tempting to do that. I doubt the government will go that route. I think what they have been contemplating, particularly the opposition parties, and particularly individuals and groups that work to advocate on behalf of these individuals who have had their lives devastated by these kinds of convictions, is looking for an amnesty. And an amnesty is a retroactive decision that the government can make in order to wipe out the records of these people so that they no longer have to suffer the consequences of a conviction long term.
But when do they actually get out of jail? What would be the process on that?
Well, they would have to serve out the entirety of their sentence.
They would?
They would.
Still?
Still.
Huh. Okay, let's go to the second thing you said. I guess in the old days they called them pardons. We don't call them pardons anymore, right? We call them record suspensions now?
Yes, they are called record suspensions now, which raises the question of, if it's suspended, can it be unsuspended? So what exactly is the consequence of the change in nomenclature to what exactly has been done with these suspensions?
So should there be record suspensions for all the people currently in for pot possession?
Well, I believe that for people who have convictions on their records that are simple pot possession convictions, and only simple pot possession convictions, that they should receive amnesty by way of a record suspension, or actually a complete record deletion for those offenses. And in my view, this is a question of equality, because if we look at the disproportionate way in which marijuana-based offenses have been prosecuted in Canada, we know statistically that white Canadians and Canadians of color consume this substance at equal rates, but they are not charged and convicted at equal rates. So this is an issue that impacts communities, minority communities, communities of color, and in order to recognize the devastating impact that these kinds of measures have had on those communities, I think it's incumbent on the government to adopt that kind of approach going forward.
Can you tell us about, I've heard of this situation in Oakland, California, where they have a kind of a different program, reparations to those who have been criminalized by cannabis. How does that work?
Exactly. So in jurisdictions like Oakland, California, and I think there are some kind of reparation or preferential kind of treatment in other jurisdictions such as Los Angeles and Sacramento as well. It's primarily in California, but it stems from the idea and the recognition that in the historical prosecution of weed offenses, minority groups have been disproportionately criminalized. And in order to remedy that, Oakland, California has created or mandates that at least half of the business licenses that are going to weed businesses, so legal cannabis pot businesses, are going to be allocated for what they call marginalized or vulnerable groups, so specific identifiable groups such as people with cannabis records, in order to ameliorate and rectify the harm that such criminal records have caused for them.
We're not going to do that here.
There's no proposition on the part of the government to adopt that kind of measure, and I think that's troubling because it is a perpetuation of the idea that in the approach to cannabis legalization, the government has actually taken the same approach to cannabis decriminalization, which is that the impact on minority communities remains an afterthought.
Did you get a chance to talk to anybody in the federal government about this?
I have not personally spoken to anybody in the federal government about this.
Has this case been made to them, though?
I think that they are aware that there are rumblings about this. I know that there have been the bill is currently in its third reading. I know that throughout the history of the bill to date, there have been proposed amendments that raise things like, proposing an amnesty, and that has been done by the opposition party, and the NDP. And so there is really an understanding or a knowledge or an awareness on the part of the government that this is in their radar, this is in their purview, and it's possible to do it.
But they've chosen not to so far.
They've chosen not to do so.
Okay. Let me, we had Bill Blair on earlier in the program, who's, of course, the member of parliament responsible for shepherding this all through. And he insists that once C-45 is passed, past the House of Commons, the Senate has its look, Governor General gives royal assent, it is the law of the land. Organized crime will be reduced significantly as a result. You buying that?
Well, I think that is a statement of fact, and I don't have any statistics to back up that fact. I don't know what proportion of organized crime is linked to marijuana sales and distribution. I do know that what the bill does is it also targets consumption, and that is not a supply side issue. That is a demand side issue. And so if we're saying that we're trying to stop we're trying to stop organized crime, then why is the approach of the bill so demand side oriented?
You think that's got it backwards?
That's got it backwards.
What would you prefer to see?
Well, I think I would prefer to see a piece of legislation that decriminalizes the possession of marijuana wholesale. And a bill that is oriented towards harm reduction rather than a criminal approach.
Now, they say they are, philosophically, they say they are taking that approach, that they're now going to look at marijuana not as a sort of a criminal-oriented issue, but as a health-related issue. You buying that?
I'm not buying that because we know from evidence that you cannot disassociate harm reduction from the phenomenon of criminalization. We know that from looking at the Supreme Court case of Bedford. We know that the criminalization of institutions or practices around prostitution, but also other kinds of sex work, resulted in harms that were recognized by the Supreme Court under Section 7 as deprivation of, as violation of the Charter in those cases. We also know that from the operation of safe injection sites. Safe injection sites are in effect, amnesty zones where individuals can go and inject themselves with drugs that they happen to have an addiction for. And the reason that they do that, and the reason that these areas, these zones are effective, is because that they are zones where it is not criminal to do so.
It's more about health than crime.
It's more about health, and the individuals no longer face the specter of criminal charges and the stigma associated with criminalization, which prevents a lot of people from going forward and getting help for the root causes that cause drug use and addiction.
Well, this bill is almost law. I mean, it's almost there. So my question now for you becomes, what do you plan to do about it? Are you thinking of a charter challenge or something like that?
Well, I am thinking about a charter challenge, and I'm thinking about a charter challenge in the context of of Section 15. Section 15 guarantees equality before the law and under the law. And we know that in the in the way that the government has, or in the way that the government has sought to enforce marijuana legislation, we see a disproportionate impact, a negative impact on minority communities, particularly African Canadian communities. And we've had that recognized in case law, and we've had that recognized in studies and social science research. And my position is that what this government is doing by failing to address that fundamental flaw and that fundamental inequality in our system is perpetuating that inequality. And the government has a responsibility to remedy those kinds of equalities when they occur.
So you clearly think they got that aspect of the bill wrong.
They got that aspect of the bill wrong.
What did they get right?
Well, what they got right is that it's better than what was the law before. I think there are other things that the bill has gotten wrong. I know that one of the objectives of the bill is to decriminalize or prevent young people, or to protect young people.
Right.
And I've heard that the position of the government is that, in fact, this bill does remove criminal sanctions from young people with respect to weed. And what the text of the bill actually says is that if a young person is, it is actually a criminal offense for a young person under the age of 18 to be in possession of more than 5 grams of cannabis. If that person is in possession, that young person is in possession of more than 5 grams of cannabis, they are given a ticket. A ticket is a civil remedy. It's a civil consequence. However, we have to look at the bill in its entirety and see what happens and look at it in its context, and the context of the way that this might play out on the ground. You've got a young person who has a bill, who has a ticket. On the face of the ticket, you've got an amount that must be paid and a date by which it must be paid. Now, I don't know how many conscientious 14-year-olds who received a ticket would make that deadline, but the consequence under the bill for not making that deadline, for not paying the amount within the specified time, is that that individual, a conviction is entered against that individual that becomes part of their judicial record. So there is a weak spot in the legislation that allows for criminal records to continue for people under the age of 18 for pot-related offenses. And I think we have to look at that in the context of the entire criminal code, because that is a criminalization of that is an offense for which a young person can receive a criminal conviction that anybody over the 18 cannot. There is no other offense in the criminal code for which a young person can be convicted that an adult cannot be convicted for.
Given that the LCBO is going to be responsible for selling this stuff, should we be treating this product more like we treat alcohol?
I actually think that if we are using the approach of harm reduction, then we still have a lot of work to do with alcohol. Alcohol is, in fact, a lot more dangerous in many respects than pot, than weed. And we've taken a lackadaisical approach, I believe, with discussing what the social determinants of resorting to alcohol is, particularly with respect to historical trauma and mental health issues. Those are so intimately tied with alcohol. So we've got a lot of work to do with alcohol to begin with. But in terms of catching up, I do believe that we need to catch weed up to the point where alcohol is at now. And one example of the discrepancy of that is it is illegal for an adult to provide cannabis to a young person, the same way it is illegal for an adult to provide alcohol to a young person.
Right.
But if we look at what the bill proposes for the consequences of doing that, you see that the bill proposes that the maximum consequence of an adult providing cannabis to a person under the age of 18 is 14 years in prison. The maximum consequence for alcohol is a fine, or maximum, I believe, 1 year in prison.
That does suggest quite a different priority for the government, doesn't it?
It suggests a completely different orientation and approach, and it suggests a continuation of an approach that really deems cannabis as a hugely problematic substance that is more problematic for society than even alcohol.
Okay, I got time for one more question, maybe 30 seconds left here. Can you see a time after C-45 is implemented and tweaked for the better?
I can. I believe that we have a great legislative system. Canada is a country that functions quite well, and our lawmakers are diligent and take their responsibilities quite seriously. I think it's incumbent on individuals and members of society to communicate to the government their discomfort in and their disappointment in the way that this bill has turned out, and for the government to respond in kind with amendments to the bill.
Which you have just done. Annamaria, it's good of you to join us on TVO tonight. Thanks very much.
Thank you so much for having me.
The Agenda with Steve Paikin is brought to you by the Chartered Professional Accountants of Ontario, helping businesses stay on the right side of change with strategic thinking, insightful decisions, and business leadership. Are you on the right side of change? Ask an Ontario CPA.